Justice Botsford, unlike Florida in 1961, Massachusetts has extended the right to appointed counsel beyond even the limits set forth in Gideon. Yet there is much work to be done. You sat as a Superior Court judge before you were elevated to the SJC. And a view from the bench, both as a trial court judge and an appellate judge, what did you see at the time? And as a practicing lawyer, what I would see would include, as Bill talked about, overwhelmed public defenders who are underpaid. I'm recalling the LaValle case from a few years ago where, what was the hourly rate? Was it $35 an hour?
It's not much more now.
Right? And there was a lawsuit brought by the Bar Association on behalf of the unrepresented or underrepresented criminal defendants who were facing trial under these circumstances. Your view from the bench.
Sure. Let me just say, though, I feel in support of Massachusetts that it is worth noting that 8 years before Gideon was decided, by rule, the Supreme Judicial Court required there to be counsel available for those who couldn't afford in criminal, in felony cases. So we have a history that actually parallels and somewhat predates, but that's not the question that you asked. I think that one of the things that Bill just said, which is true, that the Gideon promise is totally unfunded, and that means that states can deal with it as they will. Massachusetts, and those, and I think New York is one of them, that have dealt with it on a local basis, I think over time, the evidence shows are much worse off in terms of providing counsel than those that have dealt with it on a statewide basis, which Massachusetts has. But what I would notice, just as a generalization from sitting on the bench, was that what we have now is a kind of bifurcated system. The Committee for Public Counsel Services has a branch that is staff lawyers that work for the committee as staff lawyers, and then they also have a private counsel division, which are the attorneys who have private practices but take cases and represent indigent defendants. And what I noticed mostly, as a generalization, not always true, but was that sitting on the Superior Court, when a defendant was represented by one of the staff attorneys working for the Public Counsel Services, you could depend on as a general matter, a very effective representation. Forceful, informed, just excellent as a general matter. That is not so true, or certainly not uniformly true, from the private counsel division. So you have this right within the state, I would say, some distinction that is broad, that exists between the nature or the quality of the lawyers representing defendants. I don't know, well, more money would help, obviously. And that LaValle case was about, the one that you mentioned, was about that private counsel solution. People not getting paid and not getting paid enough. But without, on the one hand, if the whole system were state employees providing services, it wouldn't work legally because you have conflicts of interest. And it also raises, and I think we see this right now within the state, the specter that if everybody is working for the state, then the state starts cutting the funding, and so that the caseload increases, et cetera, et cetera. So it's kind of you're damned if you do, you're damned if you don't. But back to the question, I do think, based on what I saw in court versus what I read about other states, that we are incredibly lucky in this state. But as a general matter, certainly, as I say, at the public counsel level, the representation is excellent. And it gets increasingly excellent the more serious the crime. So we're blessed. But that's certainly not the case in other countries.
Thank you.